seated. All right, the last case on the docket is Citizens Property Insurance Corporation versus Thomas Ueberschaer. I certainly hope I said that correctly. Counsel, you may proceed.
I'm Robert Dees, representing Citizens Property Insurance Corporation. I'd like to reserve 5 minutes for rebuttal, please. The three issues that I'd like to discuss today are the applicability of the VPL to citizens, particularly where a total loss was caused by flood, but there was some wind damage. Also, the other coverages issue, which is the law and ordinance, other structures and loss of use, and then the prejudgment interest issue on the cross appeal. Beginning with the VPL, after the briefing in this case, a panel of this court decided the Farm Bureau case, and I believe Judge Thomas was on the Farm Bureau panel. Farm Bureau, like Mirswa, was a 2-to-1 panel decision in which the
Counsel, isn't there a decision in Farm Bureau Casualty Insurance Company versus Cox Controlling?
I'm sorry, pardon?
Isn't this court's decision in Florida Farm Bureau Casualty Insurance Company versus Cox Controlling on this point?
Oh, no, it's not, and I was just about to explain why it's not. Moving over to that issue, Judge Benton wrote the majority opinion in Farm Bureau. He also wrote last month this court's decision in the Litvak versus Scylla Properties case, and I believe that Judges Padovano and Lewis were on that panel. That was part of a class action to which citizens had agreed to try to get this issue to the court, and we're here now. But in footnote 1 of the Litvak opinion, Judge Benton, who wrote Farm Bureau, said that the issue of the applicability of the VPL to citizens insured property has not been decided by this court. Specifically, he said that Farm Bureau does not control this case because Farm Bureau applied to a private carrier. This case applies to citizens. Citizens was created by enabling legislation that must be taken into account. That enabling legislation has to be weighed against the VPL and any conflicts among those resolved. Before getting into that statute, I wanted to just briefly describe the facts in this case. Mr. Ueberschaer's house was on the beach in Santa Rosa County. Citizens issued a policy in the amount of $456,000, which covered wind damage and excluded flood. The house was damaged in Hurricane Ivan. In December of 2004, Santa Rosa County issued a notice of determination stating that the dwelling was substantially damaged as a result of flooding from Hurricane Ivan. It did not mention wind. Mr. Ueberschaer's policy covers windstorm, but specifically excludes flood. Citizens determined that the amount of wind damage to the property was approximately $48,000, which was about 10% of the value that it was insured for, $460,000. It paid that amount less the deductible. Mr. Ueberschaer demanded policy limits under Mirswa. Citizens declined, and this lawsuit followed. No discovery took place in the trial court because of the pendency of a motion for appraisal that was filed by citizens. Nonetheless, the case proceeded to summary judgment over citizens' objection. The parties submitted conflicting affidavits as to the extent of the damage to the property, and citizens argued that the notice of determination was not binding and that it could submit evidence that the house could actually be repaired.
Well, counsel, if this court determines that 627-351 sub 6, which is the specific citizens provision, applies and distinguishes this case from Cox, then what is the ideal result in your opinion? I assume then it's remanded. Your client conceded wind damage, or some amount of wind damage. I thought I saw a $212,000 figure.
The plaintiff claimed 200 some odd thousand We argued it was $48,000.
All right, so there's a dispute of factors regarding the extent of the wind damage.
Right.
And that's got to be litigated.
Right. So the case would be remanded to determine the amount of the wind damage. If the wind damage is what Citizen says it is, then it's paid everything under that coverage that it owes. If the finder of fact determines that wind caused the total loss, then Citizens would have to pay policy limits.
So it's your position that since Citizens is a creature of the legislature, and the legislature expressly limited Citizens to wind-only coverage, then the Misra opinion does not apply in this case?
Well, I'm not saying that it's limited to wind-only coverage. I'm saying it's prohibited from providing flood coverage.
It's specifically excluding flood coverage.
Excluding flood, correct. Since no discovery was done below, there was no evidence about whether Mr. Ueberschaer had flood insurance or how much flood insurance he recovered. Citizens did submit evidence below, though, that its premiums do not include the possible exposure for paying flood damage, and that its premiums would have to be increased substantially if it were required to pay for flood damage.
Was this argument raised below that Section 627.351(6) closely reinforced statutes specifically excluded this particular coverage, and that
I'm drawing a blank on. I'm sure that it was. I believe that it's set forth in. Yes, it's in Citizens' memorandum in response to Mr. Ueberschaer's motion for summary judgment. That's where the affidavit is also about our premiums not including exposure for flood.
This statute provides that Citizens doesn't have to require the homeowner to get flood insurance, but they have to give them some sort of a notice, right, that they're not providing flood insurance.
Right. The insured either has to obtain flood insurance separately or sign a form that says, I understand that if I don't buy flood coverage separately, my property is not covered for flood damage.
So this statute makes it quite clear to the homeowner, assuming a homeowner were to read it, that Citizens is not obligated to provide flood coverage.
I would submit that the wording could hardly be more clear.
Okay, but how is that any different from the insurance contracts that were at issue in all the other cases, Mirswa and the case here? Every one of those contracts had a contract provision saying that they didn't provide flood coverage, and if anybody read it, they would understand that there was no flood coverage, yet the courts seem to say, well, the valued policy law, says a peril, any peril.
Yes, the courts did say that.
How is the statute? I understand Citizens is a unique kind of a company set up by the state government, and here you have a statute that part of what sets it up that makes it clear they don't provide flood coverage. But how does that fact alone make it any different from the companies at issue in Mirswa and in the case before this court?
For the reason that I believe prompted Judge Benton to say in Litvack that, hey, we have not decided this issue. And it's.
Well, I understand the distinction. I'm trying to understand the difference, if any. Yeah, you got one public company and you've got, I don't know, State Farm, whoever else it is, private company. One has an exemption by statute. The other has a limitation of coverage by statute. The other has a limitation of coverage by contract. And now the question is, how do these things relate to the valued policy law? And apparently Judge Benton said in the opinion, I take you at your word, well, look, Citizens is a public company. We're not talking about public companies. Not yet. Now we are. Why is it different? Why is it different?
Well, it's different because the law is clear that if a term in an insurance policy conflicts with a statute, the statute prevails.
So your argument then is in that regard, this statute is a whole lot stronger than simply the exclusion clauses that were at issue in the other cases, because those were just parts of an insurance contract.
This is a statute of equal force and effect as the VPL, and this court should use the standard rules of statutory construction to resolve any conflict between those two statutes before you even get to the insurance policy.
And one of those rules would be this statute being more specific than the value policy law. I assume that's one of your arguments.
That's correct. First off, let me say what I think is in conflict, and then there are actually 4 statutory construction rules that I think apply.
You're into your rebuttal time, which is fine with us, but I just want to let you know.
Okay. Then I'm going to go straight to the statutory construction and try to get through and save a little bit of time. The first is the statutes are supposed to be read in pari materia when they can be read in conjunction with each other. That can be done if the court interprets the VPL in the way that Citizens suggests. Second, the more specific controls over the general. This is very specific enabling legislation, talking about what Citizens can cover and what it can't. Third, where there's conflict, the later in time takes precedence over something before. Citizens was created in 2002. The latest amendment to the VPL was 20 years before that. And fourth, to the extent that this court finds that the VPL might be ambiguous, that ambiguity would need to be resolved in conjunction with the very unambiguous Citizens enabling legislation.
So we found in Cox it wasn't ambiguous.
That's what the majority said, that it was not. I would just point out that there have been 6 appellate judges that have interpreted that clause in the VPL. 4 have said it means one thing, 2 have said it means another. The majorities in both cases obviously take precedence and win, but I think that that is at least some indication of being able to read the statute in different ways. Unlike Mearswa and Farm Bureau, however, this court, in interpreting that clause, if any, and under the policy for such total loss, has to also take into account Citizens enabling legislation. And when it does that, the conflict goes away and the policy provisions in Citizens policy are enforced.
The clauses in both this case, casualty, as well as in Mearswa, are very similar, if not identical clauses, exclusionary clauses.
And the policies in our
Yes,
case
that's
versus
correct.
the others,
This
yes.
case as well as in the Mearswa case.
Yes. The policy provisions are probably indistinguishable.
So your only basis for distinguishing in terms of liability purposes would be the statutory basis based on the statute, even though the policy languages in both cases are the same.
Right. In Mearswa and Farm Bureau, the clear policy terms were overridden by the court's interpretation of the VPL. In this case, before you get to the contract, the VPL has to be interpreted in light of and in pari materia with Citizens enabling legislation, which is more specific.
On the last issues in this case, briefly, if we find that this enabling legislation controls, what occurs there on the law and ordinance issue you've raised on appeal?
Well,
no coverage there, correct?
That's correct, because the wind would not have caused the total loss. Well, assuming that it goes back and
So
that's
some of
what's
those issues
determined.
could still be subject to litigation, correct?
Right,
Okay.
right. But I think this court's decision in Gallman, which Judge Padovano was on, already determined that issue for this court, that the VPL does not apply to these, and that was the basis of the trial court's ruling.
We'll give you an additional minute, and we'll also give Mr. Rosenblum an additional minute, and I'll give you a fair chance to sum up. So you'll have 2 minutes when you get back up. And I'm sorry, were you done? I thought you were.
Yes,
Yeah,
I'm done.
thank you. Mr. Rosenblum, you have a cross appeal. You can reserve time for rebuttal on that if you like. It's up to you.
I'll reserve 1 minute, but I'm just going to, let me just give 30-second argument on the cross appeal. The Kirkland case from this court controls the prejudgment interest issue. Citizens thinks that Kirkland was impliedly overruled by the Percival case from the Florida Supreme Court. I've read it 10 times, and it doesn't have anything to do with the facts of this case, and I'm going to leave it at that because Kirkland's right on point. Before I get into the enabling legislation, let me just get that ordinance and law issue out of the way. I want to make it clear to the court that the position the Sabalo court took and the position that Citizens is taking is you don't get the law and ordinance coverage unless and until you incur those additional expenses necessary to make the modifications. There is a stipulation in this record that Mr. Ueberschaer incurred at least $114,000, which is the 25% policy limit. So if this court holds that Mirzwa and now Cox applies to Citizens, that issue's over. If it doesn't, then it'd have to go back to the trial court to determine what percentage of the 114 is applicable to wind and what percentage is applicable to flood. Now, let me get to the enabling legislation, and there's a lot in it's one of the longest subsections of a statute I've ever read, and there's a lot in there for everybody, but let me break it down a little bit. But before I do, let me tell you what I think the result of what Citizens wants in this case. Here's what's going to happen if Citizens is correct on that issue. That the people on the north side of Highway 98 in Santa Rosa County who are insured by Farm Bureau and State Farm and other private carriers are going to collect the policy limits under the valued policy law, and the people that live on the south side of Highway 98 who are insured by Citizens are only going to get 10 cents on the dollar. Now, I respectfully submit to you that the legislature did not intend that result. What Citizens want is they want Mr. Cox, who had Farm Bureau with an HO3 form policy, to receive his policy limits, but his next door neighbor who has an HO3 policy with identical language written by Citizens is not going to get his policy limits. I cannot imagine that the legislature intended that result.
So you're saying, and see if I understand it, that if the legislature meant what this court said it said in Farm Bureau, they must also have meant that to apply to Citizens. Absolutely,
and let me tell you why. It's actually in. I will rely on the enabling legislation also. And I'm quoting from subsection 6, a, paragraph number 2, says the corporation shall provide insurance for residential and commercial property for applicants who are in good faith entitled but are unable to procure insurance through the voluntary market. For the purpose of this subsection, residential coverage includes both personal lines residential coverage, which consists of the type of coverage provided by homeowners, mobile homeowners, dwelling, tenants, condominium unit owners, and similar policies, and commercial lines residential coverage, which consist of the type of coverage provided by the condominium association, etc. So in other words, the legislature said, Citizens, you fill the vacuum left by other carriers. Provide them with the same type of coverage. Again, in subsection C, the corporation shall adopt the following policy forms. A, standard personal line policy forms that are comprehensive multi-peril policies providing full coverage of a residential property equivalent to the coverage provided in the private insurance market under an HO3, HO4, or HO6 policy. Provide equivalent to the coverage provided in the private insurance market under HO3.
But didn't the legislature subsequently say we did not mean that in the valued policy law? And wouldn't that kind of undo your argument? In other words, the legislation that came along in the wake of Mirzwa, where they changed that.
Well, that was in 2005, but we know Cox has nothing to do with this case.
No, but what I'm saying, your argument here appears to be that, well, they must have meant for Citizens to have the same exact effect as a private company.
Well, they changed it for everybody in 2005, both private carriers and Citizens. I don't remember.
In the act of doing that, didn't they say we didn't really mean that to begin with?
Well, they said it was, this has been resolved by Cox, I respectfully submit. That's the same argument Farm Bureau meant, and the majority in Cox held that 2005 says the legislation says it shall not be retroactive. So I respectfully disagree with the court and would suggest to you that that's already been decided.
I'm not saying it's. I'm probably not making myself clear enough, but I'm not saying it's retroactive. I'm not arguing that point. But Mirzwa and this court said that the valued policy law means a certain thing. The legislature, after Mirzwa, said, no, we didn't really mean that. We recognize we can't do it retroactively, but we didn't mean that. And I guess what I'm saying is, doesn't that subsequent legislation sort of undercut your argument that the legislature meant to treat citizens the same? Because they meant that they never meant it for it to be that way to begin with, apparently.
Well, that's surmise. I don't want to get back and use all my time re-arguing the Cox case, but the bill that passed the legislature in 2005, I mean, you can say, I think it's pretty obvious that it was in response to Mirzwa, but it was not corrective legislation. There was a bill pending before the legislature that was a corrective measure. And the legislative history said, we're correcting it. This is, what we meant all along. And it didn't pass that.
Let me not let you get bogged down in that then. And let me just ask you this question that to address something came up in one of Judge Thomas's questions about 627-351, which deals with citizens being a later expression of legislative will, contrary to the valued policy law.
Well,
why is that not the case?
Those rules of construction are helpful only if there's a conflict between the valued policy law and the enabling legislation, and I submit there's not a conflict. And if with the court's indulgence, I'd like to break down this subsection Q that citizens relies on. It says and what I'm going to hope to show here is what the legislature is saying in subsection Q is no different from what Farm Bureau said in the Cox case and what the other private insurers are saying. It says the corporation shall not require the securing of flood insurance as a condition for coverage if the insured or applicant executes a form approved by the office affirming that flood insurance is not provided by the corporation, and that if flood insurance is not secured by the applicant or insured in addition to coverage by the corporation, the risk will not be covered for flood damage. Well, the risk under an HO3 policy for flood damage, whether it's the Farm Bureau policy or the citizens policy, is not going to be covered for flood damage whether the insured executes the form or not. There is a specific flood damage exclusion. But the point is that neither Mr. and Mrs. Cox nor Mr. Ueberschaer has made a claim for flood damage. They have made a claim for wind damage. The VPL tells us, and Cox tells us, what the amount of money you receive for that wind claim is. And if it happens to have some overlap with a non-covered peril, so be it. But that was the case in the Robinson case, the dry rot case cited by Judge Benton's majority opinion, and others. So there is no claim for flood damage here. I want to make that clear. And then it says a corporation policyholder electing not to secure flood insurance and executing a form as provided herein, making a claim for water damage against the corporation shall have the burden of proving the damage was not caused by flooding. Well, I mean, that doesn't add or subtract from anything. There's no doubt about it that the citizens policy in this case and the Farm Bureau policy in Cox case does not cover flood. If there's an earthquake out in the Gulf and a tsunami comes in and it's just flood and it knocks the house down, there's no coverage. But Cox tells us that if there is a total loss caused by a combination of perils, one covered and one not covered, the valued policy law controls. And nothing in subsection Q says any different. And as I said, if that is different, then we're going to have a hodgepodge of coverage that's really going to be a mess.
Counsel, don't we have a hodgepodge of coverage even under Cox now because it doesn't apply to partial losses?
Well, the partial losses, well, that's true. That's true. But the partial legislature, in its infinite wisdom, made an exception for partial losses.
I guess my question then is,
Yeah, you do have a hodgepodge, but you'll have an even worse hodgepodge. And again, it goes back to legislative intent. I believe that the legislature intended for citizens to step into the shoes of the private insurance carriers who wouldn't write coverage south of Highway 98, if I could use that, and to provide the same coverage. I don't think they intended to provide those people with less coverage. And by the way, there was some mention about wind-only policies. I think, Mr. Dees, this is not a wind-only policy. It's a regular homeowner's policy that covers everything that Mr. and Mrs. Cox have.
But Counsel, argument regarding the sub-Q subsection is very interesting, but essentially your argument is that subparagraph can only kick in when there is a flood-only event. It can never apply, such as in the case here, where there is flood and wind damage and a total loss.
Well, the purpose of that statute is very clear. The purpose is to warn insureds that the policy they're receiving from Citizens does not provide the flood-type policy that you get from that's underwritten by the federal government and FEMA. That's the purpose. It's almost like an uninsured motorist rejection clause. They want to make sure that the insured understands it. There is no intent in that statute, in my judgment, to give Citizens some super authority to avoid the valued policy law that private insurers don't enjoy. That just wouldn't make any sense to me.
So, Congress, it's your position that the legislative intent in creating Citizens was to provide the exact same coverage as private insurers provide?
Yes, Your Honor, and that's exactly what the statute says. And it even goes so far as to tell the Citizens what policy forms to be written, and there are HO3, HO4, HO5, HO6. It just depends on the various coverage. And again, I want to repeat, if you take the Cox policy out of the record here and compare it to the Ueberschaer Citizens policy, they are identical. They may have some different curly cues at the top of the page, but the wording is identical.
But counsel, what about the notion that the legislature created a publicly funded insurer of last resort, and by this subparagraph made it clear this insurer of last resort covers wind damage only, and the homeowner is warned in no uncertain terms, and in fact, quoting from the brief, or reading from the brief, notwithstanding any other provisions of this subsection, the corporation may deny coverage to an applicant or insured who refuses to execute the form described herein. So not only are they saying, look, you're either going to have proof, well, they tell the corporation, you don't have to require proof of flooding insurance as long as they sign this form. But if they don't sign this form, corporation, public corporation, you may deny coverage to them. Well, that's pretty strong language, isn't it?
It all goes back to the same purpose, though. The purpose is to inform the insured, the Citizens insured, that Citizens, even though it's underwritten sort of by the state of Florida, a governmental agency, is not writing this governmental flood insurance you get through a federally backed FEMA program. And obviously they didn't deny coverage for that reason here, or we would have known about it. But I've got another statutory argument that the court needs to consider, and that's from the valued policy law itself. The valued policy law says, in the event of the total loss of any building located in this state and insured by any insurer as to a covered peril, the insurer's liability shall be, etc. Now, Citizens is an insurer. They've admitted in the briefs that they're an insurer. We have filed as supplemental authority the provisions of the definition sections in Chapter 624 that state what the definition of an insurer is, and I'm not going to go through those now in the limited time I have, but they clearly apply to Citizens. And then it goes on to say that every insurer must comply with the insurance code, and it lists the chapters and all of that stuff, which includes Chapter 627. And then those statutes go on to carve out certain exemptions, that the fraternal benefit societies don't have to comply with this chapter and this type of, but nowhere in 624, nowhere in the enabling legislation, nowhere in the property insurance portion of the code does Citizens receive an exemption from the VPL. They receive some other exemptions. For example, there's a statute exempting Citizens from regulation by the Department of Insurance. But I submit that if the legislature wanted Citizens to be exempt from any provisions of the insurance code, it would have said so. For example, we filed a request for attorney's fees in this case under Section 627.428 that applies to insurers. I haven't seen a response from Citizens that says, oh, wait a minute, we're not an insurer. We're some super quasi-legislative body. Well, the fact is they are a little different, but there is absolutely no difference between an insurance company, a private carrier like Farm Bureau who says, we don't cover flood, and Citizens who says, we don't cover flood. And I would respectfully, most respectfully, suggest to the court that if we carve out that distinction, we're going to get a real mess in Northwest Florida, much worse than we've got right now. We've already, I mean, everybody knows we have serious problems with property insurance in this state, but with all the criticism, whether it's deserved or not, I don't know, of Citizens, and now if we give them this further exemption, it's going to create chaos. So I would respectfully urge the court not to buy into this argument that they somehow deserve this break that we're not given to State Farm and we're not given to Farm Bureau, and I just respectfully urge the court to affirm on all issues with the exception of the prejudgment interest issue, which is controlled by the Kirkland case.
I have 2 minutes. Thank you. A few comments in response. First off, it's not Citizens that says that it's not responsible for paying flood. It's the Florida legislature that said that, unlike the other insurance companies with policies.
But is this really, I was listening carefully to Mr. Rosenblum, is this really an issue about flood coverage or responsibility to pay for floods? Seems to me it's more of an issue about what the extent of your liability is for wind coverage under the valued policy law. Why should your liability for wind coverage, I know you don't cover flood, let's just take that as a given. Why should your liability for wind coverage be any different from State Farm's liability for wind coverage under the value policy law?
Because I would submit to the court that in this case, given the summary judgment posture, facts have to be construed in my client's favor. That is that the wind damage was $48,000, house was worth 10 times that much, and flood.
We addressed that in Cox.
Pardon?
We rejected that argument in Cox. It doesn't matter if it's 5%. Right? That's our holding in Cox, that if there's any wind damage, in other words, I appreciate your answer, but in response to Judge Padovano's question, the question is, aren't you a wind insurer whose client experienced a total loss, and under the valued policy law, your liability, if any, shall be for the policy limits? How does that subsection change that outcome?
Because I would submit that if my peril of wind caused $48,000, that could not have caused the total loss. The notice of determination issued by the county in this case, that they based their claim on that it's a constructive total loss, says that the house was rendered a constructive total loss by flood. That's flood, and that's what we're being held liable for.
Judge, follow up.
Oh, go ahead.
But the record in this case provides us with the fact that there's some wind damage here, correct?
Yes.
And the house is a total loss, correct?
Well, we
You're
contested
arguing
that below.
That should be remanded for further litigation.
Right. We submitted an affidavit saying that the house could be repaired.
Right. With that question off the table, under the VPL, though, if there's wind damage and the house is a total loss, if that question, even if it's remanded and then determined against you because of the elevation of the first floor, et cetera,
right,
then your coverage is for the value total policy limits unless this subsection that we've been discussing today changes the outcome.
Yes, Your Honor.
I mean, your entire case rests on this subsection, doesn't it?
That is the strongest part of the enabling legislation. There are references throughout the 40 pages that are very difficult to read that differentiate us from flood. That when Citizens assesses insurers to cover deficits, they do so on a basis of their total premium except for NFIP policies.
I have two questions, Counselor, before you sit down. Would you agree with counsel that the intent of the legislature in regards to citizens was to provide the same coverage for the citizens of the state of Florida as as the consumer could have obtained from a private insurer in terms of legislative intent?
Obviously, it's difficult for me to say what the legislative intent was, although I would say that before Mearswood, nobody anticipated that somebody was going to hold a wind carrier liable for flood damage, and so when Citizens was created, there was no reason for the legislature to think that that was going to happen. It did happen. That's unfortunate for the private carriers who did not have enabling legislation like we do that stands on par with the valued policy law and has to be construed against it.
I think I understand your response, but let me backtrack again then. At the time of the enabling legislation creating Citizens, at that time, was it the legislative intent for citizens to provide the same coverage as an insurer could obtain through the private market?
Yes, and that the legislative intent was that citizens would not be responsible for flood coverage, and subsection Q made that very clear.
Well, counsel indicated that this was a claim for wind damage when the peril was covered by something else as well. But this is a claim in this case for wind damage. In other words, there was damage to the premises by wind.
Right, which we paid for.
Okay. Now, can you also explain how the affidavit of your engineer contradicts the county's determination that the house was substantially damaged under the Santa Rosa County Building Code and thus had to be demolished and rebuilt?
If I could go down and rewrite that affidavit, I would. It says that the house could be rebuilt, that the walls are plumb and that it could be rebuilt. I wish it was a little more specific, but I think that it does maybe not carry the weight of the evidence, but at least create a question of fact. Thank you.
Thank you, counsel. Mr. Rosenblum, you have a few seconds left, and I would give you more time, but I don't think he addressed your cross appeal. So I don't think you have any that you could make.
I feel a little disadvantaged because he got to discuss issue 1, which he did not raise in his initial argument. But I'll just stand.
All right, thank you.